Greetings of the day. Myself Chitra Sharma, Assistant Professor with AISSMS College of Hotel Management and Catering Technology, Pune. Subject which we are covering is hotel law, and the most important topic which we will be seeing today is about strike, layoff, closure, lockout, and retrenchment, which comes under industrial law. This is a huge problem, and this law has a specific provisions for all these things. What is the objective of this presentation is being, this act came into force in year 1947. The objective of the act was to promote industrial peace by facilitating the investigation and settlement of industrial dispute through negotiation. It is a labor legislation to protect the workman against the victimization by the employers and to ensure social justice to both employers and the employees. The unique object of this act was to promote collective bargaining and to maintain a peaceful atmosphere in the industries by avoiding illegal strikes and lockouts. So let us see what is a strike. A strike is supposed to be known as one of the oldest and most effective weapons of labor in its struggle with the capital for securing economic justice. The basic strength of the strike lies in the laborer's privilege to quit a work and thus bring forced readjustment of condition of employment. It owes to its origin to the Old English word striken, to go. Under Industrial Dispute Act, Section 2Q, the strike has been defined as a means of cessation of work by a body of person employed in any industry acting in combination or on a concentrated refusal or a refusal under a common understanding of any number of persons who are or have been so employed to continue to work or to accept the employment. There are few essential elements of strike, like there has to be cessation of work. Cessation of work means there is stoppage. Cessation means stoppage of work. The cessation of work must be by a body or person employed in any industry. The strikers must have been acting in a combination. Strikers must be working in any establishment which can be called industry within the meaning of Section 2J. There must be a concentrated refusal to work, refusal under a common understanding of any number of persons who are or have been so employed to continue to work or to accept employment. They must stop to work for some demands relating to the employment, non-employment, or the terms of employment or the conditions of the laborer or the workman. There are few components of the strike also which are very essential, otherwise it won't be considered as strike. Like the most significant is a cessation of work. It has to be very expressed as abandonment, stoppage, omission of performance of duties of their post, hampering or reducing normal works, hindrance to the working or suspension of work, discontinuing the employment or breaking their contract of services, or refusing or failing to return to or resume employment, or refusing or failing to accept the engagement for any work which they are usually employed for. This is one of the most essential components. It can be also said elements of the strike. If cessation of work is not there, then it won't be considered as strike. Concentrated action, this is another important ingredient of strike. The worker must act under a common understanding. The cessation of work by a body of persons employed in any industry in combination is a strike. Thus, in a strike, it must be proved that there was a cessation of work or stoppage of work under a common understanding, or it was a concentrated action of workers, or there was a cessation of work by workers under acting in a combination. One thing must be kept in mind, that the refusal of work means refusal to perform duties which the workers are required to perform. If the workers are in liberty to do a particular work or not to do a work, their refusal to work does not amount to strike. Next, let us see what is a lockout. Lockout is quite similar to strike in a term, but it dates back to 1860 and is younger than its counterparts in the hands of workers. Strike by 100 years. Formerly, the instrument of lockout was restored by an employer or group of employers to ban a union membership. The employers refused to employment to workers who did not sign a pledge or not belong to trade unions. Later, the lockout was declared generally by a body of employees against a strike at a particular work by closing all the factories until the strikers returned to work. Now, we have to consider an amount when lockout will be considered as legal. The Act treats strikes and lockout on a same basis. It treats one as a counterpart of the other. Thus, what holds good is also holds bad. What holds legal is also illegal. Justified is also unjustified for strikes. Holds the same for the lockout. As such, the provision of Act which prohibits the strike also prohibits the lockout. The object and reason for which lockouts are banned or prohibited are the same for which strikes are banned or prohibited. It is because the employer and the employees are not discriminated in their respective rights in the field of industrial relationship between the two. This Act does not lay down any guidelines to settle the claims arising out of illegal lockout. There are certain prohibition of lockout, like in similar circumstances, the lockout has been prohibited in public utility service under section 22(2) of the Act provides that no employer carrying on any public utility service shall lock out any of his workmen without giving proper notice to them and within 6 weeks before locking out or within 14 days of giving notice. Before the expiry of the day of lockout specified in a such notice as said, during the pendency of any conciliation proceeding before the conciliation officers and 7 days after the conclusion of such proceedings. So thus it makes clear that the employer has to comply with the same condition before he declares lockout in his industrial establishment, which the workmen are required to compile before they go on strike. The condition for both the parties are almost same. Now let us see what is a layoff. The term layoff has been defined as a failure, refusal or inability of an employer on account of shortage of coal, power or raw material or accumulation of stocks or breakdown of machinery or natural calamity or for any other unconnected reasons to give employment to workmen whose name is borne on the muster rolls of the industrial establishment and who has not been retrenched. Muster roll is basically attendance sheet. It is a bonded register and it is compulsory for any establishment to have. A layoff is a condition where the employers are constrained to deny work to their workforce owing to the condition that they bring forth a temporary inability to keep their business going. The set case scenario can happen only in a continuing establishment. That means the establishment which is on a running condition. There are few key ingredients of layoff. That there must be a failure, there has to be a refusal or inability of the employer. This failure, refusal or inability should be offshoot of the shortage of coal, power or raw materials or the accumulation of stocks or breakdown of machinery or natural calamity or for any other unconnected reasons. The names of laid off workers should necessarily feature on the muster rolls of the establishment. The said workers should not have been retrenched. Now, what is a compensation for laid off period? A workman who has been laid off is entitled to compensation equivalent to 50% of total basic wages and the dearance allowance for the period of layoff. The said compensation can be availed only if the employee has done a continuous service. That means he is a permanent employee of at least 1 year, and this will be detailed in the upcoming session of this article. Along with this, the muster roll of the establishment should bear the worker's name to avail the compensation. A casual worker or who is on a probation period cannot avail such compensation. Refusal to accept alternative employment, absence from establishment, strike or deliberate slowing down of production could be grounds that would be entailed dissentimental of such compensation. Now let us see what is a retrenchment. Retrenchment, as the name says, is by the employer of the service of a workman for any reason or whatsoever otherwise than the punishment inflicted by the way of disciplinary action. A. Voluntary retirement of the workman, or retirement of workman on reaching the age of superannuation if contract of employment between the employer and the workman concentrate contains a stipulation in that behalf. The termination of service of the workman as a result of on-renewal of the contract of employment between the employer and the workman concerned on its expiry, or such contract being terminated under a stipulation in the behalf of contained. Termination of the service of a workman on the ground of continued ill health, like he is not able to attend the office continuously for a period of 2 months or 3 months, can lead to retrenchment, or something like he has come to age of 60 is a retirement age in India. So if he has attained that, that will go for retrenchment. The key ingredient in the termination of workmen from the service by the employer. This does not mean that the employer can retreat a worker as a punishment by way of disciplinary action. The special provision which has been provided for retrenchment, it is pertain to know the worker who has served at least a year of continuous service cannot be taken out from the service unless a notice of 3 months advance notice is given and a prior permission has been taken from the appropriate authority. The said application must be submitted by the employer along with the reason for why he is being retrenched. The said application will be taken into consideration, it will be scrutinized, and the inquiry will be there, and there will be provision where both the parties will be heard. Then the result will be decided by the judge and it will be recorded thing. If there is no reply from the appropriate authority for a period of 60 days from the date of application, then the permission shall be granted. Further, it is noted that the said decision could be reviewed by the said authority suo motu or on application from any sides of the party. Now let us see what is a closure. The Act defines closure as a permanent closing down of a place of employment and a part therefore. Here, the employer is constrained to close the establishment permanently. Nonetheless, the due procedure must be complied with when it comes to rolling out a plan of closure. The said procedure, as set out by the Act, has been detailed below. The procedure, nonetheless, do not apply to undertaking set up for the construction of building, bridges, roads, canals, dams, or for any other construction work. There is a special provision for closure also, that it has to necessarily apply at least 90 days in advance, that is 3 months, to the appropriate authority. The copy of said application must be given by representative of workman as well. The said application will be considered and reasonable opportunity to be heard shall be given to the employer as well as workman. After considering the same, the appropriate government may or may not grant the employer to close. Even here, the government does not respond within 60 days from the application, that is at least 2 months, the permission shall be granted. A similar provision for the review of decision exists even here. So we can conclude saying that employers may be forced to deprive their employees, invoking the case scenarios as explained above. The Industrial Dispute Act has been successful in setting out standards for mutual respect and requirement for solid reasons as a precondition to bringing this into play. These provisions aim at protecting the workers' right while respecting the employer's point of view as well as. This presentation has been made with the help of Portal Law Book, which is authored by Mr. Amitabh Devendra, and it is an Oxford publication. There is a link has been given in the description box for attempting the quiz. Please attempt and have a safe and great learning.